afternoon. I'm Tina Cruz, one of the Associate Directors at the Center for Teaching Excellence. I want to welcome all of you here in the studio with us and those of you watching from a distance. I want to introduce today Karen Lear Edwards. She teaches in the retail department in the College of Hospitality, Retail, and Sport Management, and she's going to talk to us today about copyright issues. So please welcome Karen.
Thank you. Thanks, Tina. And it's a delight to be here. Welcome, everybody. And I want to ask you a couple questions. How many have posted an article from the news, the Wall Street Journal, whatever, on their web page or on their Blackboard page? How many have borrowed some great photo and put it into their PowerPoint, or maybe even embedded a video clip and put it into their PowerPoint presentation in class? Yes, okay. How many have copied a fabulous poem or article or news event and passed that out to their students in class? All right, well, you're probably a very good teacher, but you're also walking the line on copyright issues. So we're going to talk today about some issues of what you can do, what you shouldn't do, what you should do if you're going to do a handout or a embedding of a video or what have you. We're going to try and keep you on this side of the copyright law. How does that sound? Like a good plan? Okay. All right then. Excuse me as I click our screen. This is my little disclaimer. We're going to see it again, and I'll tell you what that's all about in a minute. Our objectives today are to help you identify your rights and duties under federal copyright law. You're also going to learn how the fair use and the teach exceptions to federal copyright law will apply to you. And hopefully you're going to be able to better instruct your students about their use of copyright materials. So that's where we're headed for the next hour and a half. Well, today what we're going to look at is, are four specific topics. First, we're going to take a look at what is copyright anyway. Pardon me. Then we're going to take a look at exceptions to the copyright rule. And the mother lode of exceptions is found in fair use, but there's a couple other ones that we'll be taking a look at too. We will take a look at technology and web-related issues. And then we're going to take a look at the special issue of music. And I'm going to give you a contact name that hopefully you won't have to run into on the wrong side, okay? All right, so let's get rolling. Oh, we're going to save time for question and answers, but if there's a burning question that you have during the presentation, just flag me down and I'll respond as it comes up. Okay, so what is copyright? Copyright under federal law is an original work that is put into some kind of fixed form. And under the current copyright law, as soon as that original work is put into fixed form, the creator has the copyright. And what is copyright? The right to copy or not copy. So if I write a poem and I scratch that down on a piece of paper, it can be the back of a, guest check at a restaurant or whatever. It is mine. I have the right to sell it, distribute it, or just keep it all for myself. Okay? So I have the right. Where does this right come from? Well, in our Constitution, the founding fathers decided that they wanted to promote the useful arts and sciences, hence copyrights. Now, how does giving the creator of an original work promote the useful arts and sciences? Well, the whole idea is if we give you the right to benefit from the book you write, or the article you write, or the movie you produce, or whatever it is, we're going to give you the right to, usually, the money that's associated with that. And money's a pretty big incentive, isn't it? It makes us get our creative juices going. So there might be other motivators, but the fact is, by giving creative people the rights to their creative works, even though it's for a limited time, it fosters the useful arts and sciences. And why do I bother saying this? Because copyright law as we understand it now, in practical application is all about the rights owner trying to hang on to this right and, you know, get the infringers. But the whole idea of copyright is to get creative juices flowing. So the intent was not to protect the copyright owner necessarily. It was to help our society as a whole. And that's an interesting point. So you as educators, what does this mean to you? You are out there helping educate the greater community. And so we do have some rights under the exceptions that we'll discuss. All right? So what is a work? I said for it to be a copyrightable thing, it has to be a created work. All right? Ideas and thoughts cannot be copyrighted. All right? However, things like literature, drama, music, lyrics, even choreography can be copyrighted if it's put into some kind of fixed form. Computer software and programs, that's a hot one, isn't it? Yeah, okay. Computer-based and net-based creations are copyrighted as well, and so we'll get to that. It's a hot topic. Sculpture, artwork, movies and TV shows, okay? These are all works, creative works. If you write it down or put it in some kind of fixed form, and you might be thinking, well, how can, you know, if you're in the drama department or what have you, how can choreography be put in a fixed form? Well, if you write down whatever the moves are, or if you record it via video. So there are many different ways that creative works are put into fixed form, and one is writing. That's what we're all really used to. Books, articles, periodicals, what have you. But audio recording is copyrightable as well. So if you really wanted to hear me sing, and I sang a song and recorded it, I own the copyright to that recording, right? Okay, trust me, you don't want to hear me sing. I threaten that to my students, though, every now and then. All right, how about video recordings? Of course, those are copyrighted as well, okay? Tangible art, the sculpture of David, okay? Computer-based materials, aha. Web programs, etc. Or my web page itself, all right? Now, the Federal Copyright Act gives the creator of this creative work that is put into fixed form the exclusive rights. Exclusive, that means nobody else has the right, right? Exclusive rights to do what you want with it. Things like reproducing it, selling it, or distributing it, publicly performing or displaying the creative work if it's a drama or what have you, licensing it to others, okay? That's where very often you get the cash flow coming in. But I will bet that at least half of you license your creative works to others for the purpose of publication in scholarly journals, right? Okay, so license doesn't always include money in return. Okay, and currently the term of the copyright is for as long as the creator lives plus 70 years. Okay, the copyright law has changed over the years. However, currently, and since I think 1989, the term is the creator's life plus 70 years. So if you write a book, your estate will continue to have the rights in the book if you indeed didn't license it out to others. Okay? And that's a very valuable asset, in fact. All right, what questions so far? Anything? All righty. Well, the copyright notice, don't be confused, it is no longer required for works since 1989. But why might you want to put a copyright notice on your web page or your book or your article or your poem, whatever it is you're creating? Lively group we have?
A reminder?
Okay, a reminder to people who look at it, because you are throwing out there a reminder, this is copyrighted. Many people do not know that things on the web, a web page itself, your works, whatever, might be copyrighted. You want to extend that right and make people aware. So generally it's going to identify the copyright owner. It will show the year of the first publication, and it's going to notify those potential users that you as the right holder, or whoever it is that holds the rights, intends to hold the rights. Now, the web in particular is a hotbed of copyright infringement, and we'll talk about that. But if you go to a web page and you scroll all the way down to the little bitty writing at the bottom, you usually see a C in a circle and then the name of the organization that owns that web page. But when you open a book, you turn the title page, you see on the left-hand side the copyright date, all the years that it was published, and who the publisher is, who owns the rights. And they're telling you point blank, reproduction is expressly prohibited unless you get our permission, right? Okay, and so if you are creating something, you want to reserve the rights to it. But similarly, if you're looking to borrow or use someone's work, you want to respect their rights as well. And so that's what we're looking at today. Now, let's take a look at some exceptions to that general copyright rule. The general rule is if someone creates an original work, puts it into fixed form, it's theirs. They can do what they want. And unless you get their permission, you can't copy it or use it. But, that's the big, snafu. But the creator can transfer the rights. All right, there are 4 exceptions. 1, if the creator transfers the rights. 2, public domain. 3, works for hire. And 4, fair use. We're going to take a look at creator transferring the rights. And one of them I've mentioned already. You write a scholarly article. It gets accepted in that A-rated journal. You're delighted. You're thrilled. Are you going to make them pay for it? No. You would probably pay them to take it, right? Because you want to license them to publish your work so that it enhances your portfolio. But let's say you write the textbook. You want to sell that, right? You want to get some kind of royalty off of that. Although it indeed is prestigious as well, this is your opportunity to make a few extra dollars perhaps. You don't have to sell it though. You can give it away if you want. You can give away whatever you want. In fact, if you're here in person, you have a handout which the authors who own the copyright have given permission to freely duplicate for educational purposes. Those of you listening, I'll give you the link to that website shortly. Okay, so the owner has the right to sell or license it to others or simply to give it to somebody. Or like the handout you've got. Or some other kind of agreement. You can contract for whatever you want. You, as the creator, can do with it as you wish. But remember, very often the hat's on the other person, where they own it and they're the ones with the exclusive right to give, license, sell, or what have you. Okay? So, the one exception to the copyright rule that the creator retains the right in that work is if the creator transfers the right via one way or another. That's the obvious, right? Okay. How about the public domain? What's the public domain? We talked about the intent of the forefathers being that we're giving copyright so that it helps to foster the useful arts and sciences, and at some point the material will become part of the public domain. What is it? What do you think? What does it sound like? Right. It's out there. It's free for everyone to use, right? So how does something become part of the public domain? Well, first off, I told you that there's a term that the copyright right extends to, and that's the creator's life plus 70 years. Well, once that copyright has expired, the item is in part of the public domain. So you no longer have to ask permission or pay or whatever to get the item. Any older works, books, articles, photos, etc., are now part of the public domain. But the author can release something into the public domain if they wish by releasing their right and encouraging everyone to use it and expand upon it. That doesn't happen that often, though, just FYI. Okay? Big surprise, right? All right. However, there's another big exception to the copyright rule, and that is things that are U.S. government materials. Unless it's classified information, most government documents are accessible and part of the public domain. And that makes sense, doesn't it? Because who is the public? You, right? All of us. And therefore, most government documents are part of the public domain, and you may use them without asking for permission. If the government doesn't want you to have it, in most cases it will be classified information or information that they will deny under the Freedom of Information Act exceptions. Okay? What questions so far? Now, I have the public domain enlarged here, but the public domain is not as big as it sounds. Rights holders really do retain their rights in most things. And so there's not that much in the public domain in the big scheme of things. All right? So let's take a look at the next exception. Works for hire. This matters to you as an educational professional. Now, the general rule under copyright law is this. If you create it, you own it, unless your job is to create these materials. Now, we're educators. Part of our job is to make a syllabus. Maybe part of your job is to set up an online course. Maybe part of your job is to create PowerPoint notes or other materials for your students. Does that mean the university owns it because it's a, quote, work for hire? Works for hire are owned by whoever is the employer. Now that would be the general rule. And I see some ears perking up right now. Well, here's what the University of South Carolina does for all of us. And we'll take a look at it in the next slide. But the university says, we know that the copyright rule says if it's a work for hire, that the employer owns it. But we want to do a couple of things. Number one, we want to be able to attract and retain the best and the brightest. Number two, we want to give you the rights to manage your own works. Therefore, USC gives the right back to you. They say, we don't want it. It's yours, in most cases. And so, where a work for hire is part of the creator's job, or if you are hired specifically for the purpose of creating a certain work, then it does belong to the employer. But don't forget, the employer has the right to give the right back to you, and that's what USC has done, unless a few circumstances are met, and I'm going to touch on those in just a moment. Okay? All right. What questions so far? All right. Oh, yes, question.
Can I just ask a
And talk loud if you don't mind, because I'm hearing impaired.
Is that typical? Most colleges do the same thing, or is that changed from college to college? University?
It is typical that in order to remain competitive, an institution of higher education to attract and retain the best and the brightest really needs to give it. But if you are considering a change, which I hope you're not, but let's say hypothetically you have a friend who might be considering going elsewhere, it would behoove you to double check that institution's copyright policy before accepting a position. Yes, excellent question. Okay. All right. So let's take a look then. The general policy at USC is that USC intentionally modifies the work for hire doctrine under copyright law and gives back to USC faculty copyright in their own academic work. So if you make that PowerPoint slide or presentation, or you write that workbook or whatever it is that you're doing, including your scholarly research, USC gives it back to you, okay? Unless these 3 points are all fully met, and this is right out of the copyright policy. You can get it off the USC website. Okay, if these 3 things happen, then USC owns it, and you need to know that up front. Okay. USC is only going to own the copyright if it's a directed work. In other words, if the university specifically requests you to create the item, okay, whatever it is, and, these are not or, these are and if substantial resources are either allocated, administered, or invested by the university, okay? If it took a chunk of change, right? Now, what is the dollar amount put on, quote, substantial resources? I don't have the answer to that. But I can say it's going to be more than just the use of the USC computer, for example, okay? Using your laptop that you've been issued is probably not going to amount to substantial resources. But if there's some kind of university-related grant or what have you, maybe so. And then, again, not or, it's and. 1, 2, and you have a written agreement between the university and the faculty who is creating it. So there can be no mistake. Everybody knows up front that this is a work for hire. You're doing it for the university. The university perhaps will pay you an extra stipend or something for doing it. You know up front that the university is going to own it, no questions, okay? All three elements under the current policy are necessary in order for USC to be claiming the rights, okay? But if you've got all three, don't think you can go sell it later, okay? Because once you enter into the agreement, you've given it. You've licensed it, okay? What questions on that one? Alrighty then. Let us then take a look at the mother lode of copyright exception for educators. And this is the fair use exception. The fair use exception. And I've jotted down, and we're not going to visit this website at the moment, but the USC Copyright Office has an information page that you might find useful, okay? And that is, let's see, /copyright/fair use. Take out that S. Sorry about that typo, okay? .html, okay? So you can take a look at that for a little recap provided by the university on fair use, etc. All right? Now let's spend some time talking about fair use. I'm going to state the obvious. If you need to use it, just ask. Permission from the copyright holder negates any need for the copyright exception. All right? So don't worry about finagling around the copyright law and how can I make this so that it sounds like it's fair use. Just ask. Okay? If you ask and the copyright holder gives you permission, presto magico, you can use it. Be sure if you ask for the use, that you ask for the use for ongoing semesters. Otherwise, they might assume you only want to use it one time, and that reserves for you the right to keep using it. Okay? But ask. You will be surprised at how many copyright holders will give you permission to use it, whatever it might be. Okay, well, you might be thinking, how should I ask? The University of Maryland College has a page that's out there on the web. I'm not showing you the document. I'm providing you the link in case you want to check it out. They have what I consider to be a pretty nice little sample letter where you fill in the blanks and send it off to the copyright holder and hope to get your response. All right? Now, email works great. You can use the same elements via email and get a much prompter response, but I highly recommend and encourage you to keep a copy of that email that grants you permission. Okay? All right, you're going to want to hold on to that. All right? Questions so far? All right, I believe my next slide is a sample for you. Oh, no, it's not. I've got a sample somewhere. We'll come along in a moment. Okay. Well, let's say you don't have time before the class starts to ask for permission, or you haven't yet heard back from the copyright holder and you've sent out your request. Well, then there's a couple of circumstances that might occur. One, for yourself and your personal research or for your teaching. And then the other is, what if I want to make multiple copies for my students? Let's take them one at a time. First, let's take a look at fair use, the fair use exception as it applies to making a single copy. You can make a single copy of a copyrighted item for your teaching purposes or for your personal research. You can make one copy of the following. A book chapter, an article from a periodical or newspaper, a short essay, story, or a poem for your teaching or research, or a chart, a graph, a diagram, or drawing, picture, etc. One copy. All right? Now, that's simple enough to get me ready for my teaching lecture or to get me ready in my research or what have you. Okay? But what about when you want to make copies for your students? Let's take a look at that. You see before you the tip chart, which has a lot of the general rules that we're going to be talking about. And for those of you who are viewing it, you can either Google the Tech and Learning website or go to the web page that's shown there. They kindly offer a chart for classroom use that is very helpful, handy rules of thumb for you. All right. Fair use for multiple copies in the classroom. You can make one copy per student of the following. Okay? But wait. You can't charge more than the cost to copy. Don't be making money for the department via this technique. All right? Times are tough, but we're not there yet. All right? All right. So you can only charge copying costs. In fact, if you can, I recommend you give it to the students free if you really want them to get it. We all know the difficulty of getting them just to buy their textbooks, right? Okay. So as long as you follow the rule, okay? There was a conference on educational use of copyrighted works where a lot of scholars and experts in the field, higher ed as well as copyright law, got together and made recommendations. These are recommendations. So although I call it a rule, it's not a law. But you're smart if you follow it because it's all we've got right now. Okay? And as a general rule, if you follow these 4 steps in your distribution of materials to students, you will be okay. But, you know, that's my disclaimer is that's no guarantee. However, more than likely, you will not have a problem because you are following what's called the CONFU guidelines, C-O-N-F-U. Okay? And if you want to look them up yourself, just Google CONFU and it's out there. Okay? So the first thing is brevity. And we'll touch on what we mean by brevity. The next thing is spontaneity. Aha, should be last minute, all of a sudden. If you had time to contact the rights holder, you should have done that. Okay? Cumulative effect, we'll take a look at that. And then finally, notice of the copyright. All right, so you do need to follow these guidelines to protect yourself when you're making multiple copies for your students. The first thing, brevity. Let's take a look at brevity. I'll come right back to this one. Let's take a look at brevity. A poem should be less than 250 words if you're going to use it under the fair use exception. And these are on your little tip chart, I believe. Okay? Prose, if it's an article or a story or essay, it should be less than 2,500 words. If it is an excerpt from a larger work, you should use between 500 and 1,000 words, or don't go over 10% of the work. Can you get where we're headed? What's the purpose of this? So that whoever holds the rights is not getting the short end of the stick, right? You're using a snippet, not the whole work. If they need to buy the whole work, send them to the bookstore, right? Okay. One chart, drawing, or picture per book or periodical issue. So you get the idea that brevity means don't use too much of it, otherwise you should be sending them to get the book or the work. And in fact, part of this rule says that, whatever you distribute to students cannot replace consumables, workbooks, and textbooks. Because the purpose of the copyright law is to foster the creative arts and sciences, as you know, and part of that is to get people to create these books, workbooks, textbooks, and how do you get them to do that? Through the opportunity for making money. This should never replace textbooks, all right? So let's go back to my sample. I use a PDF stamp tool if I am scanning and printing or scanning and sending to my students a document that I'm using under the fair use exception. If you just make a PDF stamp tool, then you can stamp it on anything that you are going to use later. If you just scan it and email it to yourself, you've got it. Okay? I like to have the print shop print hard copies of anything that I'm using, and PDF is an easy way to transmit it to the copy shop. So I recommend, whether you use a PDF stamp tool or whether you just attach some other kind of notice, you need to let the student know this material is being provided either at cost or at no cost under the fair use exception to the federal copyright law. And you need to make sure the copyright information is included. Okay? That puts everybody on notice that you've made your one copy per student and it's under the fair use exception to the rule. Now, can you keep using that same thing without asking permission semester after semester after semester? No would seem like the correct answer, and you are 100% right. If you have time to recreate it and recreate it and recreate it, the idea is you had time to request permission. So the fair use exception when you're distributing materials is for that time where you don't really have time to get the permission. So spontaneity is that issue. First off, it's got to be you don't have time to get permission from the copyrights holder. And the use has to be your own inspiration. In other words, your department chair can't say, hey, we're short of funds, we can't afford to buy new workbooks, teaching materials, whatever. Claim the fair use exception on this and distribute it to your students. It's not going to work. It's got to be your idea, not a directive from somebody else. The decision to use whatever the work is has to be where it does not permit a timely reply, or perhaps you haven't gotten the reply back yet. But again, the use of documents that you might, and materials that you might be distributing to your students cannot replace consumables. At the university, I heard individuals say things like, oh, if you can't afford a textbook, let me know. Okay? Do not copy textbooks for people. All right? Not going to work. All right? So, can't replace consumables. What questions so far? Yes.
I have a question about the single use. Does that include informal learning, like text panels for museum display, if you're reproducing an image just once, even though many people are seeing it?
Okay. We're going to talk more specifically about online courses, but with regard to fair use, like in a PowerPoint presentation, for example, if you use an image one time without permission and you state where you got it from, who holds the copyright, you should be fine. That's an example of fair use. So for current events, or, hey, I read this in the newspaper this morning, let me see if I can get an image and we'll talk about it in class today, yes, that's fine. I'm going to show you a sample. When it comes to online courses, there's the fair use rules apply, but there are also additional rules that you might want to know about, so we'll talk about that more. Will that be okay? Okay, good. Thank you. All right. So, the cumulative effect is that you can't overdo the fair use exception. Otherwise, you need to be getting, consumable materials. Okay. So, for one class term, you can only use one piece from the same author. So, if you're doing an anthology of, the works of C.S. Lewis or whoever, you need to buy the books. okay? Because you can only copy and distribute to your students one piece from the same author, or 2 excerpts from the same author. Excerpts not from textbook, I mean excerpts from some smaller work. 3 excerpts from the same collective work or the same periodical, and 9 instances of copying and distributing under the fair use exception per course. Okay? So don't overdo it is what the cumulative effect element says. Yes, question?
Well, this may go back to the earlier question or the earlier information. What do you do if you want them to read or use something that is out of print? They won't be able to buy it.
Okay.
So, I mean, does that mean you just can't use it?
Well, if it's out of print, chances are it may be under the public domain.
But how do you get it and
Okay.
distribute it is my
All right.
question.
I would contact the Thomas Cooper Library and see, because the law librarians as well as the main librarians are very well versed in the copyright rules and will be able to either get it for you or tell you how you can get it lawfully. I personally, I'm just going to be honest, have not dealt that much with out-of-print documents, and therefore I would refer you to the experts at Thomas Cooper or the law library if it's a legal document that's out there. That's an excellent question. I'm sorry I don't have an immediate answer on what you do, but I can point you in the right direction.
Sure.
Okay, thank you. Yes?
Karen, that's exactly right, because do you know Chris Brown at University Technology Services?
No. I mean, I have a lot of other questions and I've read a lot about the fair use and about copyright and things because I work in the art department and we deal with images, specifically I do. And this is this is becoming a very intimately, technically complicated issue for us. And
But Chris uses a textbook in her class that's out of copy or out of date, and the library got it for her in an electronic format that the students can get in PDF format. So I mean, she knows the real contact person. I don't, but yeah, they will work with you on that.
Okay, very good, very good. And sometimes the publisher is still in business even though the book is out of print, and they will give you permission. But use the university resources to do the legwork because they may have done it already, and gotten permission. Excellent. Thank you, Tina, for the input. But thank you for bringing that question up. I'm sure there are many who have the same question. Okay. Other questions before we move on? Yes?
If someone's using a textbook and the book is not in the bookstore for the students to buy, can the faculty make copies of the chapters that they're going to cover until the textbook gets in?
Okay. I'm glad you asked that question. The question being, can faculty members make copies of the book chapters early in the semester when the book hasn't yet arrived to the bookstore? In fact, that has happened to me. In fact, I had a custom excerpt book made through the publisher, and they forgot to put in one of the chapters. I just sent an email and said, hey, guess what happened? We're missing chapter 14. Can you send me a PDF? And will you allow me to distribute it, one copy, to each of my students? And they said, gave me the written documentation, yes, go ahead, it's our error, blah, blah, blah. Similarly, with books that have not yet arrived, the publisher will have PDF copies. I would not copy it myself. I would email them, request permission to distribute copies, and ask if they've got a PDF of chapters 1 and 2 that they would allow me to distribute, or what have you. That way, you're getting a better quality product, you're saving yourself the copying, and you're getting the permission all in one sweep. That is what I would recommend. I would not copy it without their permission, though. I would not.
And if you selected your textbook through a rep, a lot of times your rep, if you know your rep personally,
Yes.
they'll handle all that for you. You just tell them, the book's not in, I want PDF, and the rep wants to make you happy.
That's exactly
And they'll
right.
provide it.
That is exactly right. The reps will do that. That is the person who was very helpful to me. And you know your book reps, so they want to help you out. Now, many of the online versions will allow the student to download the first 20%. So if it's an online text, very often they do, acknowledging that students might not buy their book immediately, will let them download that. So that's nice if you got that, but not always the case. Thanks for that excellent question. Okay. All right. What about course packs? Anybody ever made a custom course pack with state-of-the-art, hot-off-the-press information, ready for their students, okay? This is great if you're teaching a course that's related to current events or one that constantly needs updating. I teach Retail 525, Law for Retailers, and I use entirely ancillary materials, okay? I don't use a textbook, but what do? I've heard of some professors who compile the information themselves. What I recommend is, and I'm not promoting this particular company, but this is who I use, I recommend use a service. Do not try to put a multi-owned course pack together using copyrighted material that's owned by 70 or 80 different copyright owners. Because in order to use that as your text, you've got to get permission from every single one of them. Now, the easy way is to use a service, and this is not the only service out there. However, I've had very good luck with university readers. They do the work for you. You tell them what the articles are, you send it to them, and they get the permissions. And then they compile the notebook or what have you and make it available to students. It's the headache-free way. That way, if there is a copyright issue or question, whose problem is it? It is the publisher who has guaranteed us the copyright clearances. All right? Just saves you infinite amounts of headache. All right? What questions on that? Anybody ever use one of those? You have? Did it work well for you?
Universal Copies on Main Street will do the same thing.
Who is it?
Universal Copies.
Universal Copies on
we,
Main Street?
We give them hard copies, but they do all the copyright clearance for us, give free copies to the class instructors,
Excellent.
and we'll mail packets out to students at a distance.
Excellent. So it appears as though there's a local contact as well that does a great job. Very good. Good to know if you're putting together one of these type courses. All right? Very good. Questions or comments on that one? Okay. All right. Let's shift gears then and talk a little bit about technology and the web. Issues that come up in this realm. And hopefully we'll hit on the issues that you had, in mind and those that might be on the minds of others as well. Well, general rule, government websites, usually public domain. But whenever you're at any website, scroll down to the bottom and look for the copyright insignia. All right, what does it say? If it says copyright XYZ, all rights reserved, does that mean you can just copy and paste? No, it doesn't. It means they're reserving for themselves all the copyrights and that you need to get permission. Okay, but as a general rule, government websites, the information therefrom is part of the public domain. We as the public own it. You may use it. You should still cite where you get it from. Okay? Otherwise it might confuse the reader or what have you as if it was your own work. All right? And you don't want to do that. Okay. Contrary to popular belief, the internet is not public domain. Just because it's on the internet and available to the public doesn't make it public domain. Remember how I said very little comparatively is actually part of the public domain, meaning you can use it without asking, no problem. All right? Just because it's on the internet does not make it free for use. Okay? Now, if the fair use exception applies and you're using brevity, spontaneity, etc., you can use snippets of things from the website, whatever it might be. However, if there's time to ask permission, you should do that. Okay? Let's see, what else do I have? Pearls of wisdom. Here we go. Do not repost copyrighted materials on publicly accessible website without permission. All right. The fair use exception is applying to your classroom. So, for example, this little picture of a computer in the rainbow, I've gotten from Microsoft Clip Art. Along with our license to use Microsoft, they give us license to use their Clip Art. So I don't really have to make that statement, but I'm just making it clear so anybody viewing knows that I have not snatched this off the internet from someplace. All right? But had I snatched this off the internet from someplace as long as the fair use standards apply, I would want to put a little copyright insignia, identify who the copyright owner is, and say, I'm using this under the fair use exception. Okay? Now, could I keep using it time after time after time? Semester after semester? No, because that spontaneity thing that has to do with fair use, okay? I've got to ask permission if I keep using something that I've grabbed off the net time after time. Now, what do you want to make sure you don't do? Don't repost copyrighted information outside the classroom. The fair use exception applies to the classroom, not your personal web page that's out there for the whole world to see. You might have a copyright violation. And I used to say, you know, educators, don't worry, the copyright police aren't out there. Yes, they are. They are now. Okay? In other words, there are very sophisticated computer-based programs where copyright owners can go out and see where their stuff is being used. How do you think USC gets notices of unlawful downloads? Okay? But owners of music, as well as photographs and other works, videos, etc., have the ability to go dig in and find their stuff. And so, you do not want to repost copyrighted material outside the classroom because fair use is not going to protect you. And we'll talk about online classes in a moment. Okay? So be careful. Ask for the release if the time permits. And most copyright holders, if they're not using whatever it is as a money-making venture, they're going to let you use it. And even if they are using it as a money-making venture, they might let you use a snippet because it helps promote their stuff or their item or their work, whatever it is. So very often they want the publicity. They're going to be happy to let you use it. Okay? So ask if you can. Next thing is, if you don't have the time, it's okay to use the article or the image or the photograph, whatever it might be, one time if either the fair use exception applies or the teach rule applies. And we're going to talk about the teach rule in a minute. It has to do with online courses. Okay? So if you can apply fair use or teach, go ahead and use it one time. After you've used it that one time, if you love it and you want to keep using it, ask for permission. Okay? If you post something that you have gotten online under the fair use exception and you're posting it to some kind of web format so that your students can view it at their convenience, make sure it's a closed forum like Blackboard. Or if you're posting it to your Facebook page, if you've got a student Facebook page, you need to make sure it's closed to only those that you've invited and that you have invited only your students. Otherwise, you're basically giving it to the world, and you do not have a right under fair use to do that. So, if you're posting an article, poem, image, whatever, make sure it's in a closed forum. Okay? Make sense? Question, yes?
Then can you keep it up for the whole semester?
The brevity rule would suggest that you should not use it for a longer period of time than is necessary for that particular section of course content. So, if your favorite quote or video clip or something, you've got it and you just leave it up there, that's pushing the envelope, quite honestly. There are guidelines out there that say only leave it up as long as you need it for the objective of that lesson. Okay, thank you for asking that question. Okay? All right. Well, here's my sample notice that you saw when we first started. Okay? I told you that this presentation might contain materials which have been used for educational purposes under the fair use exception to federal copyright law and maybe even under the Teach Act. Okay? And I'm letting you know that you should not download without the download, copy, or further disseminate this material without appropriate permission from the copyright holder. So if I posted my presentation on Blackboard or wherever, this is the notice that I'm letting the students know, hey, don't just grab and copy this and send it to your friends, because there's stuff on here that I'm using under fair use. And fair use only applies to my classroom setting, not every place else. All right? And so, to protect yourself, I recommend that you put at the start of your PowerPoint, if you, like me, grab stuff from the internet for that one time of hot news, okay? You give yourself this little disclaimer, and if you post PowerPoint notes for student convenience, you better be sure you've got this notice to your students. It's part of the T chapter, and we'll get to that in a moment. All right? So, if anybody wants a copy of this, just shoot me an email, and I will send it to you, okay? All right. So, here's a sample. Remember I said if you find something really great on the internet, just ask the rights holder. They'll usually give it to you. Presto Magico. I teach a business law class, and as a, quote, refresher, I teach my students about the circuit courts in the federal court system. Now, by far, the best circuit court map I have found on the web is on the webpage for the Georgia Institute of Technology at the Center for Assistive Technology and Environmental Access. Guess what? I used it one time because it was the best one I found. Used the fair use exception. Then I sent the Georgia Institute an email, and I said, you've got a great map of the circuit courts of the federal system. Do you mind if I use it in my PowerPoint presentations from now until whatever? It's the best one I've found. And my students really get it when I show this map. I got a lovely email back that said, yes indeed, go right ahead. Feel free to use it. We are granting you permission. Now, I thought to myself, I would like to show this map as my sample to my CTE participants. Does that fall under fair use? Maybe, maybe not. The permission I have is limited to the classroom. Because they said use it in your PowerPoint for your students, for business law. What did I hopefully do before I put this in today's presentation?
Contacted them.
I contacted them again and I said, hey, guess what? I am going to use, if I could, the sample that you let me use, but now I'm going to use it in a different context. I'm going to host a continuing ed on copyright in the classroom. Do you mind if I use it? And guess what their response was? Lovely once again. Yes, we would be thrilled to use it. In fact, here at our institution, we know the importance of copyrights and educating ourselves on copyrights. Use it with our blessing. Thank them for that. Yay. All right. So, what did I do? I used it, and I gave notice of who I was using it from and the fact that I had gotten permission. Now I can keep it forever. Yay. Right? It's really not that hard. Now, what about cartoons and entertainment type things? Well, I have a certain favorite cartoon that I like to use in my personnel management classes. It involves a pointy-haired boss who does management really poorly. Yeah, okay, so I write to the pointy-haired boss people, and they say, well, let's forward you to this department. They, sent me all around to whatever departments, and then finally said, it's $20 a cartoon.
Each time.
Ooh, no more pointy-head boss, haired boss. Anyway, if I wanted to cough up the money, I could continue to use that time after time after time, but if I'm not going to, I won't. Okay? Make sense? All right. So sometimes they say no, but usually if it's a, some kind of entertainment venue. All right. Let's talk more about technology and the web. Teachers can create educational multimedia projects for in-class instruction or workshops, like a PowerPoint presentation. So, if the fair use exception applies, you can use it in your teaching tool. All right? If you're using it on Blackboard, keep it closed, though. Okay? Now, what about students? Students can create multimedia projects to fulfill course requirements, but here's the thing. Make sure you teach them to identify the fair use exception and to credit the sources that they're using. and make sure they don't further disseminate the item beyond the classroom use. Okay? All right. You don't want to create copyright infringers by giving them that fabulous learning assignment. Okay? So, be careful with this. All right? What questions? All right. Another technology issue? Pardon me? Oh, you have one. Thank you. I'm sorry. I did not
That was
see.
all for student-created work, using other, students are bringing resources together to create their project, right, to complete a course requirement.
Okay, yeah. If you, many professors give students projects where they have to do a presentation, maybe it's the culmination of all they've done that semester, and very often they will snatch pictures and music and whatever from the web. Make sure you teach them how to give credit to the appropriate sources, and make sure you teach them that don't go recycling this and redistributing it, because it's only protected under the classroom environment. Yes, thank you. I'm sorry, I didn't mean to interrupt you. Didn't see. Okay. Well, what about online courses? Wow, what about online courses? We're all gravitating that way. We're doing hybrid courses. We've got lots of CTEs on teaching online in large groups and this kind of thing. It is a hot issue right now. But there are some things that you want to know with regard to online courses. First off, fair use applies. Okay, the fair use exception can be used in your online courses. But you still have to follow the rules. If you had time, ask for permission. If you didn't, make sure it's short, spontaneous, not overdoing it, and not replacing your workbooks or tests, right? Okay, there's also the TEACH Act, which is the Technology, Education, and Copyright Harmonization Act of 2002. And what this does, it extends the classroom exemptions to include audio-visual works. In other words, you can transmit pieces of music or pieces of videos or what have you in the online course setting for distance education purposes. But there are some rules that you have to follow with this one as well. And we're going to take a look at the guidelines under the TEACH Act. Okay, first of all, it has to be in the nonprofit educational context. So, those universities which are considered for-profit institutions, you see them on the side of the highway all the time, they cannot use the TEACH Act to allow them to transmit this information. So, you have to be a nonprofit educational context. Next, whatever it is has to be part of the instructional activity. Okay? You can use those copyrighted materials, but it's got to be part of the lesson. Okay? It can't be just for entertainment purposes. The fair use standards need to apply. You still have to use those standards that would apply in the live classroom. The work has to be of material assistance to the instructor. It also has to be lawfully made, so you can't go illegally download some music and then transmit it and expect it to be okay. All right, so that one goes without saying, but I'm going to say it anyway. So this material assistance standard is still a little fuzzy, but if you can arguably say it's enhancing your teaching and it's an important part of your lesson, I would say that you're okay. All right, but we haven't really had cases out there to say, you know, what the high end and the low end of material assistance might be. All right, the content has to be uploaded by you. Okay, it can't be somebody else's idea or somebody else's working. You need to limit the access only to those students who are enrolled in the course. All right. Now, arguably, your teaching assistants could have access as well. Okay, but it can't be open to every visitor who you want to come see what great stuff you're doing. It's really only for instructional purposes and only for the students you've got in this course. All right? So be sure to limit that. And then you have to make sure the content is not further disseminated. So that duty rests with the professor who's posting the items and the university as a whole. So we have to have safeguards in place And one of those safeguards is giving your students a notice that they're not supposed to further disseminate it. Another safeguard is you use a forum like Blackboard where not everybody in the world can get in there. Okay? You want to make it so that it's in a forum that is closed and available only to your students. You don't want other people hacking in, taking the stuff and further disseminating it, or you're the one who could be in trouble for that. Okay? So you do have to give your students a warning notice, and if you use Blackboard, I recommend you just post the warning notice on the announcement page and make it a permanent announcement. That's what I've done. And let me show you a sample of the warning you're giving to students. It sounds, oh, terrible warning. But actually what you're doing is you're putting them on notice. That sounds nicer, doesn't it? Yes, there we go. We're putting them on notice. Here's what I have as a sample teach notice. You can borrow it if you wish. You don't have to. You can refine it if you wish. But here's what I use. I post as a permanent announcement on my Blackboard homepage, announcement page. Notice to students, materials used in connection with this course may be subject to copyright protection and should not be copied, downloaded, or further disseminated without permission from the appropriate copyright holder. There you go. All right? In other words, I make my PowerPoints and point notes available to my students. I usually leave some blanks so they have to take notes as they go along. But the fact is, if I had an image or a quote from somebody, they now know that they can't go copy and sell these notes. They can't copy the notes, fill in the blanks during the lecture, and then sell them for $5 a pop to other people. Not that they're that valuable, but they might be to somebody. Okay. Anyway, so they now have noticed that they're not supposed to do that. And I should also discuss it with my class as well. Make sense? Okay. Yes, question?
When you say things have to be uploaded by the instructor, we have courses with multiple sections taught by different instructors who like to share materials on Blackboard. So does each individual instructor have to upload materials, or can that be done by one person and shared with other instructors?
I would argue, and you know, nothing's bulletproof, but it would seem to me if you have multiple instructors, if you have one instructor who is in charge of uploading materials because you're just more tech savvy or whatever, that should be okay. We can dig a little further, but I have not heard of a problem when each of those instructors were indeed bona fide members of the instructional team, having one person, the one responsible for putting it up there. But you know what? If I'm uploading other people's content, now there's an argument that I should double check and make sure it's really not a violation to use it, that, you know, we haven't used it before and we're just continuing to use it without getting the appropriate rights and that kind of thing. So there might be a little bit of personal responsibility that that techie person is taking on, just to make sure that we are following the fair use rules.
What about having our tech support people upload educational videos?
You know, you could argue that you use the assistance of the tech support person. I have not seen that in action. The TEACH Act is still less than a decade old. I do not know of any, it's not saying there aren't any, I don't know of any copyright infringement cases that are based upon a techie doing the uploading at the behest of the instructor. I would say it's a pretty good argument that you're okay. They're only doing it as your hands and eyes because you can't do it. However, it's not what the TEACH Act says. But I think that's a pretty decent argument that, you know, I'm not tech savvy enough to do it. I'm having this other person do it. I'm overseeing the downloading thereof or what have you. Did you have a question? No.
But if you got permission from the publisher to post it, then that would be okay for the tech person to do it.
Permission negates the fair use exception, absolutely. Thank you very much, and that's an excellent reminder. And I bet that's what Ruthie was going to remind you.
It's not. I was just going to say one workaround I've seen, and just say whether this is okay or not, is people, a lot of times you can link to other people's material as opposed to posting it on your own page.
Exactly, and that is one way that in most cases you can circumvent the need. And so where I said you can visit this web page for this information, I gave you the link And I said, go to it. There are issues, though, with providing excessive information and then linking. That is an argument that you've actually all but given it away,
But you
and now
basically
you're just giving
summarize
the
it and
link.
then give the link.
Exactly. And so that's the only thing you have to be careful of.
I
If
think
you
people
do
do
provide a
that.
link, just say, see this link for a grade map of whatever, or see this link for whatever, and just give a description of it, for a beautiful poem, or a music that demonstrates this or that kind of movement, or whatever.
Or I've seen faculty use it for course packs. They have 25 articles they wanted, found 15 of them online, and just
Right.
said, this is our course pack, these 15.
Right.
Or something like that too, which is another workaround. I mean, if it's legit,
Yeah.
it's a workaround.
It is, I'd be careful with that, because when you go to the website, is it something that the person has put out in the public domain, or are they providing it there for purposes of selling the larger product? And then you've got the problem about your cumulative effect. So I'd be really careful if you're doing, a handout with read these articles online. It may be okay, but in essence, you might be replacing published materials. Yeah. Okay. Thank you for pointing that out. Okay. All right. Let's keep moving. Other issues: software programs. Do not. Hey, did I say do not copy software programs without a license, even for classroom use? All right. So, if the university has bought or purchased X number of PowerPoint 2007 licenses, once we use them up, that's it. You can't go copy the program so that you can have it too and do an unlawful download or whatever it is, copying, unlawful copying. All right? And this happens in educational institutions where they will purchase so many for this building or so many subscriptions of whatever. That's the limit. If you need it also, you've got to go buy it or convince your department head of the necessity to do it. Okay? You can't just copy software programs unless you get permission. Are they going to give you permission? No, they're not. Although, John Gertis in the IIT section has developed a cool little game for in-classroom use that he told me at Oktoberfest he was going to let me use. Yay. So, I've gotten permission, right? Cool. All right. So, don't do that. A couple other terms. Freeware. Freeware might be free, but it is not part of the public domain. What is freeware? It is usually limited to not-for-profit uses. Some kind of system or software system that is specifically for not-for-profit uses. Now, read whatever the requirements are. Okay? How many of you use like the little animated clip art from the free clip art web pages? Okay, they're fun, aren't they? But have you read the fine writing on the free clip art page? When you do, usually they'll say, we'll let you download this and use it free, but you have to give us credit and provide our link in your presentation. Okay? So read the fine writing. Just because they say free doesn't mean there aren't additional strings attached. And if you want to use it free, you need to follow whatever the guidelines might be. Okay? So, freeware might be free, but it's not necessarily free without giving credit or anything else. Shareware is usually limited in time and purpose, and shareware is really a selling sample. We're going to let you use this program for X amount of time, and it's basically a test drive so that you come back and buy it. All right? You can't unlawfully download that and keep it for beyond the purposes because it really was a selling sample. And you're violating the terms of use if you continue to use it, so don't do that. All right? What questions? How are we doing on time?
We've got 15 minutes.
Okay, all righty, thank you. All right, videos in class, and this does not happen as much in higher ed as in the K through 12 arena, but I have seen it. Using videos in class is okay if you're using it for in the classroom or in an educational setting, if it's for instructional purposes, not entertainment. So, don't say we're going to watch Platoon as a reward or whatever, okay? it's got to be we're going to watch Platoon to learn about the Vietnam War era or what have you. Okay?
I have a question in reference to
Yes.
that. If you want to show it in your classroom, do you have to get it through the university so, you know, they've paid an institutional rate for it, or can you bring in your private copy? I mean,
Okay, good question. Do you have to use USC's version, or can you bring in your one from home? Two things. One, it has to be lawfully obtained. Okay? So however you got it includes paying for it.
Right.
Somebody paid for it. So lawfully obtained. The second thing is, when you run your at-home video, does it say this is restricted to at-home use?
Of course it does.
If indeed it does, then you're going to want to use the university copy. Okay? Unless you're just copying a snippet, and we'll talk about that in a minute. Okay? But that's an excellent question, and one we don't really think about. Who reads those, you know, informational blips? You do. Thank you. Excellent. You're my hero today. Okay. It needs to be legally made or purchased, and you can clip brief excerpts for criticism, comment, news reporting, or research, but not show the whole thing unless it is for an educational purpose. Make sense? Okay. All right. What about TV broadcasts? PBS has a lot of great info. All right. PBS has its own rules about how long you can use something for. But under the federal copyright regulations, if you want to use something that was publicly broadcast, okay, that right now rules out pay-for TV channels, right? So we're talking about PBS and the major networks, right? Okay. If you wish to show something that was in class that was publicly broadcast and you're making a copy of it, it must have been showed within the past 10 days. And you can only keep it on hand for 45 days. So, if you want a copy, buy it. Okay? You have to show it in the educational setting, and the tape must be complete and unaltered. So if you're going to tape a TV show for use in the classroom, you're going to have to show the whole TV show.
Including commercials?
Pardon me?
Including commercials?
Now, I would argue that the commercials are not part of the show. I haven't addressed that issue before, but I would argue that you could snip out the commercials. Okay? If anybody knows any differently, let me know. Yes?
So that would rule out an older TV show that was on DVD that you had purchased.
If it's on DVD, how did it get there? Was it made for sale?
Buy it now.
Okay, you're buying a DVD. We're going to specifically talk about DVDs in just one quick minute. If you're in the classroom, you need to follow these rules for videos or what have you in the classroom. If it's an online DVD, you got a little bit of leeway under brand new regulations. Okay, so we'll talk about that. But you can show a snippet for criticism, comment, etc. during class. But if you're showing, you know, the video, it can't be for entertainment purposes. Okay? All right, good questions. All right, publicly broadcast, shown within 10 days, educational setting, complete and unaltered. Okay, don't forget, if you need to use it, just ask for permission. Very often, you will get it. All right, what about music in the classroom? As a general rule, you can use the lesser of 30 seconds or 10% of a musical work if you're using this for an educational purpose. You can use a full single copy if the original is owned and the copy is used just for an exercise or an exam in the classroom. Okay? This doesn't apply to most of us. We're not going to use music for teaching purposes, but for those of you who do, please know that the fair use exception gives you some guidelines. Okay? And those are on the tip page as well, I believe. What about if you are in drama and the performing arts? You can copy an emergency copy if the night of the performance, you know, everything goes to heck in a handbasket. Okay? In an emergency, you may do that. The copyright owners will usually, though, prohibit, if you're doing a performance and it's a drama or it's a musical or whatever it is, they will prohibit you from copying that or taping it, videoing it, and redistributing it, because part of your agreement when you buy the script or whatever is they're going to limit your distribution. So you need to read the fine writing of whatever it is that you're producing, particularly in the performing arts, okay? All right. Now, what about ripping DVD clips and getting them from the web or pulling them from a DVD that you own and using it in the classroom, whether it's online or in person? The Digital Millennium Copyright Act prohibits the use of technology that de-encrypts the safety mechanism on DVDs. So you can't sell or use whatever, de-scrambling devices. Clearly, I'm not an IT person, you can see that. I'm retail. But anyway, whatever the stuff is that provides digital rights management, that is, whatever these codes are, you're not supposed to de-scramble these codes and grab snippets off the DVD as a general rule. Okay? However, there's an exception to this. Oh, by the way, penalized copyright infringement on the net, so it makes it against the law on both fronts. But there's an exception in some rules that were just promulgated, and one is that if it's a lawfully made and lawfully acquired DVD, and you're an instructor who is using it for educational purposes for higher ed, and if you're not using a big part of it, you're using it specifically for criticism or comment, or you need to use it to teach filmmaking or what have you, then you're allowed to circumvent those processes, grab a snippet of the DVD and use it. So the rule is, if it's lawfully made and acquired, the purpose is to incorporate portions for criticism and comment for learning purposes in your classroom or online, and it's necessary in order to get your educational purpose by college professors, and what, all students or just certain students? Film and media students. In fact, until earlier this year, it was only film and media professors who could do this. This is what the new rule changed, and it allowed all professors in the higher education arena to do this. But it doesn't allow all students to do it. So when you're making those assignments on projects, be careful that they know what they can and can't do. So if they're film and media students, they're okay. Other students, be careful. So you can make documentaries using these pieces and non-commercial videos. All right? This is kind of big news in the copyright world this year. Okay? It's extended to everyone, not just media individuals. How about music? Handy rule of thumb. Don't download unlawfully music. And in fact, there is a gentleman named Kenny Edwards who is no relation to me. However, he's a friend, he's a good fellow, USC employee. Guess what his job is, or part of his job is? He's a registered agent where music companies who have been violated, you know, they've got their search engines out there looking for unlawful download, they find a student or faculty member who has unlawfully downloaded their stuff. Who do they let know? They let Kenny Edwards know, right now at least, okay? They go to the federal copyright page, and there's a link where you can look up the registered agent for every university. And they send the complaint. First they send a cease and desist order, and they might send fines if it's multiple violations. Now, what has the university done for students and faculty members who are music lovers and might be tempted to download? They have provided alternatives, okay? Alternatives where you can go and download music or videos or what have you lawfully, okay? And so, if you are one, or if you know someone, have a friend who unlawfully burns DVDs, recommend to them the alternatives provided at the university website. Question?
5 minutes.
5 minutes? We're almost there.
So let's open it up to questions and answers, and I will do my best. Yes, question here.
Talk about YouTube.
YouTube, all right. The question is, what about YouTube? Can I go and download a YouTube video? It depends. Isn't that a lawyerly answer? Don't you hate it? I wouldn't, first off, I would be careful embedding it because you might have a problem. What I would do is, if there's something that I want to use for educational purposes in the classroom, I would put the link on my page, and then in full screen mode, you can just click on it and it'll go there. Okay? Don't give the big description, blah, blah, blah. That's the safest method. The problem with YouTube is sometimes people post things that they don't have the right to. And so they're violating the Copyright Act. So if you then download their violated item, you're perpetuating the fraud or whatever. So be careful. Now, very many musicians and artists promote themselves via YouTube, and they would love nothing more than for you to further disseminate their product. So it depends is the answer. Rest assured that the music rights holders are hot onto YouTube and giving notices whenever, and takedown notices whenever deemed appropriate. But you can't call it a guarantee, because as soon as somebody posts something, you might come across it the next minute before somebody gives a takedown notice. So be careful. I would use the link, and if the link suddenly isn't there anymore, guess what? They probably had a takedown notice. Okay? So that would be the safest way to use it.
We could just use the link to have students.
You can use the link, yes, yes. But again, as I mentioned earlier, be careful about providing too deep of content. Just let people know what the link is, as long as it's active. Here's what you might find. You know, just something very short. Okay?
Okay.
All right. Other questions? I wouldn't embed, though, just in case. Okay? Other questions? Yes?
Does the law say anything about how hard you have to try to find the contact information for the copyright holder? Like some things I find on the web, I'd like to use that image, but I can't find out who I asked.
Okay. The question being, what if you can't find who owns the right on the web? I would argue that you're going to have to use due diligence. And if at some point you say, well, I wash my hands of it, I'm going to use it anyway. Bear in mind that music, videos, and photographs have codes attached to them, where if that item that you found was unlawfully borrowed from, let's say it's a gorgeous photograph of South Carolina or tourism or whatever, and you want to use that in your class, and you find it on somebody's blog or whatever, and you borrow it and use it in your class, and one time, fair use, okay, but you want to keep using it, and you can't get to the bottom of who owns this image. If it was taken by a professional photographer, eventually they might find you, because photographs can be decoded to find out where they originally came from. I am not that tech savvy. You probably aren't either, and or you would have been able to get who owned it. But the fact is that you don't want somebody knocking on your door saying you're the violator when you got it from what you thought was a legitimate source. That's where the real problems come in. As far as us as educators, we don't want to stomp on anybody's rights, but the problem is that if we borrow something from a website where they have not clearly made known how to ask for permission, chances are they borrowed it themselves. Okay? So that's the risk. Okay? But I would say once under fair use you should be okay, but if you want to repeatedly use it, you're going to have to use a little bit more effort to get to the bottom of it. Okay? Excellent question. Other questions, if any? Yes?
I mean, how paranoid should we really be with this? And I mean, I want to be respectful and give credit to anyone who's done work that I use. But if, you know, as Jed said, if through due diligence you don't find the author, I mean, what is the real expected consequence? I mean, someone's just going to say, hey, I own this, can you acknowledge it, can you take it down, or we're going to fine you or the university. What is the real
consequence?
As a general rule, it has to do with how much money they're making from it and how frequent an offender you are, or the university is. That's the problem. They might look at us collectively versus us individually. So if you follow the fair use guidelines, you should be, in most cases, okay. Most copyrights holders understand the fair use guidelines, but the problem is a lot of educators don't. We think we can keep using it and keep using it and keep using it. And we also sometimes think we can replace purchased products, and that's where most of the problems come in. So as a general rule, if you follow the fair use and teach guidelines and do not violate the repeatedness or the amount, the brevity issues, you shouldn't have a problem. The problem is that the rights holders...
When there is a problem, what kind of consequences should you are expected?
Okay, so let's say
Because
we've
you
got
come
a
back
problem.
and charge the university, say if you had 100 students, University 101 used something, and we had 3,000 students that use this, we want $30,000 from the university for something.
Chances are, and you could ask Mr. Edwards for more information about this, but he's the one who's going to get the complaint to start with. It would be reasonable, especially in this context, to first issue a cease and desist order, or cease and desist notice, or what have you. But if we collectively as the university have stomped on the rights of that particular rights holder several times before, this might be the magic time where we're going to have to pay money. It just depends on the circumstances, quite honestly. It's kind of hard to predict if you don't know what other violations we've had. I'd like to think that we're in pretty good shape.
Right. And is it more likely that they would come after the university?
Yes.
Or after me personally?
Well, it depends on what this stuff is. As I understand it, if you're downloading music for entertainment purposes, they're going to come after you. They're going to notify the university if you use a university computer, but they're going to come after you because you're doing it. However, if you're using things for educational purposes and you can demonstrate that it's for educational purposes, then it's more likely to be a university issue. And that's part of the reason why we have CTEs like this one, because part of the rules say you've got to educate your faculty on what is appropriate and what is not. So in the educational context, it is my sincere belief that most of the errors are good faith errors. Nobody's really out there trying to circumvent the rights of legitimate owners. Okay?
And I guess the other side of that then is, I guess that in the unlikely event that they do come after something that I've done, I know that, at least I believe that the university has some liability. I mean, my liability towards my students is I'm protected by the university. The university stands behind me to a certain extent. Is the same thing true with this, or am I all on my own?
I am an attorney, but I am not legal counsel for the university. I'm going to refer that question to my friend George Lumble. Okay? I have an opinion, but I'm not the official university attorney, and so I would hesitate to respond to that question. But I'm sure if you give George an email, he will be more than happy to respond to that. Please know that I am not trying to, get out of that question. I am not authorized to give legal advice on behalf of the university. Okay? Thank you. It's an excellent question.
We want to thank Karen again.
Get off the TV. So
Afterwards, if you have questions, I'm sure Karen can hang out for just a few minutes, maybe.
Sure.
But we want those of you who are here with us, please fill out the evaluation that's in front of you, and if you're online watching from a distance, please fill out the online evaluation. And we just want to provide Karen with this certificate of our appreciation.
Thank you very much.
You are welcome, and let's give her a round of applause again.
Thank you. Email me at klear@sc.edu if you wish. klear@sc.edu. And I'll answer any questions I can.
Thank you. Thank you very much.
Thanks a lot.